Viewers, welcome back to the Personal Injury Law Show. Before the break, we were talking about the case of Insight. Now, what was the decision of the court in that case, Nunzio?
Oh, well, they found for the plaintiff and that effectively the exclusion clause didn't stack up and they couldn't exclude liability. So it was I think the plaintiff was awarded, from memory, about $22,000 in compensation.
That's correct.
Yeah.
And the exclusion clause didn't stack up. Why, Alvin?
Why? The plaintiff resided in New South Wales. The incident took place overseas. The court said that applicable law will be the law where the incident took place, not New South Wales law.
So, in effect, viewers, what happened was the exclusion clause wasn't wide enough. It was very poorly drafted by the operator. That's why the plaintiff won in this case. Let's get on to the next topic of volenti non-fit injuria. What does it mean, guys? Someone tell me what it means.
Well, basically, voluntary assumption of risk. You assume the risk of something happened and you do so voluntarily.
Who does that, Alvin? Who assumes the risk voluntarily?
It all depends. I mean, how do you define risk? And the next element is whether it's obvious. Certain things might be obvious to you, like walking along a footpath, there's a big hole, broad daylight, blatantly obvious to you. There might be certain instances where it might not be obvious to you, but to others it might be.
So, in other words, this Latin term we're referring to, viewers, is basically saying that you voluntarily assume the risk, so you're not entitled to anything. Let's go to
just quickly on that. I suppose the classic example of voluntary assumption of risk is if you're playing a game of footy, you get injured during the game, you accept that risk. You appreciate, you understand that you may get injured by reason of the game. And that is probably the classic example, but we're looking at examples that go beyond that and we can get out of that clause.
And just on that point, the Victorian County Court recently decided a very interesting case of Perry and Albert Park Indoor Sports Centre. You're in the case, Nunzio, so tell us a bit about the facts.
Yeah, Tony, this was my client and we were fortunate enough to be successful before Judge Bowman at the County Court of Victoria, and we just got the decision in December 2012, so a very recent decision. And look, it's a landmark decision in the sense that it's the first time that I suppose the principles of obvious risk and voluntary assumption of risk has been determined under the Wrongs Act, which is Victoria's governing act. So it is a big decision. Basically, in terms of the facts of it, our client was at the Albert Park Indoor Futsal Centre, which is now where the Grand Prix occurs, where the pit lane is.
Yep.
Watching his sons and his friends' sons play some futsal, which is basically indoor soccer without nets. And the setup of this premises is that there's adjoining courts, and between each adjoining court, there is effectively like a hallway that adjoins each court. Game was over, our client was following his son and his friends, and between courts 6 and 5 I think it was determined. He was about to walk out into court 5 because the entrance is back at court 2 or 3, or the exit, sorry, and a ball came flying from the adjoining court, couldn't see it, hit him in the head and suffered a fairly significant neck injury.
Alvin, to the average person, getting struck in the head by a ball doesn't sound like it's significant. Why was it significant in this case?
The issue here is he was an entrant to the game. He was about to leave the premises. He was going to go about the normal exit way. When he was going down, the doors were latched. He couldn't get out of the place.
They were locked.
They were locked. Then he had to make his way up again through another exit way, which was permitted by the occupier of the premises. He's walking along. He gets basically hit by a ball. There was no netting at that place.
But of significance in that case, he got hit in a hallway. He wasn't even in the.
No, look,
he wasn't a spectator.
Look, we did a site inspection together with the judge, and when you're in this hallway, you can only see, I suppose, from the other court, the right side of the court. You can't see the left side, so you don't know where the balls are coming. So one ball can be flying at you, and they're the hard soccer balls, and you would not have an idea whether one's coming, and hence why we thought that the case was viable in that regard.
Okay. Now, if the doors downstairs weren't latched, like you said, Alvin, this would never have happened. Is that correct?
Absolutely, absolutely. Or if they were latched, they should have at least some nettings along the area where our client was walking along. That would have prevented the incident from taking place.
All right, let's stop for a minute. This particular room where they were playing a soccer match had netting to protect the windows, correct?
Yes.
But on the side where people had to walk through to get from one end to the other, there was no nets, correct?
Exactly right.
So someone's made a decision that those balls could break a window. Is that correct?
Yes.
And that's why it was nets.
Yes.
If they can break a window, you'd imagine it could break someone's head or damage someone's neck. Correct?
Exactly
Absolutely.
right.
So that would have been pretty damning, you would have thought.
Look, and there was also evidence from the plaintiff that while he's watching the game, while his son was playing and his friends, that he actually was spectating from behind the net. So he's appreciating the danger that could come from a soccer ball. But in that walkway, which I say is effectively akin to a hazard, he could not appreciate that risk.
So what is the major principle be to come out of this case, Nunz?
Well, basically, I suppose, for the defendant ran the case that our client should have been aware of the risk that was approaching him. And secondly, that basically he assumed that risk. And what the court said is that basically that to prove that something is obvious, you also need to prove that you've assumed that risk, and that wasn't led by the defendant.
And in this case, the plaintiff couldn't have assumed the risk because he didn't know the risk was there.
Absolutely. Couldn't see it coming.
You know, he didn't know balls were flying around because he's in the, what was it, like
The hallway.
between the two
Yeah, it
hallways.
was like a little narrow hallway.
Basically,
And, and look, we obtained an expert opinion from an engineer, and he said basically 3 cheap alternatives. 1, unlatch the door. 2, get a big warning sign on the corresponding wall saying beware of balls. Or 3, some netting. And they were very cheap alternatives for the defendant to avoid this accident.
Can I just stop you on that point? A lot of cases over the years have been one on lack of signage. Is signage conclusive and complete in most instances, or a lack of signage, Alvin, in your opinion?
It all depends as well at the end of the day. I mean, the overriding principles of the cases are, even if there's a risk, it's the individual who sustained injuries. They have to be aware, have the idea, knowledge, and freely accept that. They have to appreciate the nature and the extent of the risk. And if you don't appreciate the nature, if you don't know the nature, there's a lot of cases talking about that, then you're not liable in that sense. The defendants say it's a defense, a complete defense. Plaintiffs, if they're not aware of that, don't have the knowledge or haven't turned their mind towards that, then the defense of the defendant completely falls. There might be a different issue regarding contributory negligence, which we'll talk about in a later episode, but that's different.
Okay. Viewers, this is a very interesting case, and this is where we'd love to get your feedback on Twitter and Facebook, so please give us your views. Nunzio, anything else you want to add to the discussion?
Look, I'd say just listen to viewers. Look, you know, when you are undertaking these recreational activities, just be mindful of what you're signing, and be, I suppose, aware of what's happening. But because, as I said, once you sign it, unfortunately, there is, that can hurt you at times. So.
Alvin, is there anything else you want to add?
Absolutely. If you're ever injured, my best advice is go and see a lawyer, seek their advice, seek their opinion, because there can be certain exceptions, as I mentioned, about gross negligence, even though you've signed a contract. However, if there's any gross negligence, you can still succeed. That's why you need to see a lawyer.
And on that note, we've reached the end of the episode, viewers. So, Nunzio and Alvin, thanks for coming on board.
Thanks, guys.
Thanks,
Thanks,
Tony.
viewers.
Thanks, viewers.
Thanks for watching. Go to our website and watch previous episodes. Go to Facebook and Twitter, and also stay tuned for future episodes, and always stay safe.